All right. Well, I'll welcome everybody. Thanks for joining us. Remind you that we always like to give a little door prize at the end of these presentations, but you must be present to win. That means you need to stick around to the end, and then Lindsay from our team will tell us who has won, randomly selected. Also want to, again, thank you for joining and remind you that we're here to discuss today the unpredictability in the legal environment of the state of Oklahoma. And we're excited to have Sam Hammons from Sequoia Information Systems to give us some insight. And Sam, I think you have also have a guest joining you. I think Jan Voss is with us as well. And so Jan's going to be available to answer some questions as well. But Sam, go ahead and get started and give us some insight about how Oklahoma's judicial system is and how it impacts our economy. So Sam, we'll turn it over to you.
Okay, great. Thank you, Chad. I'll give you a little background and history here, how we got started with this project. I was happily practicing law back in the 80s and 90s after serving on the staffs of two governors and on one governor's cabinet. And it morphed into kind of an international practice. So I had a client overseas that was looking to build a plant in the United States somewhere. And they had been hit with a big verdict. The guy had run off the road. He was drunk. He hit a tree. He died. They were sued in one of these judicial hellholes, you might say, forum shopping deals. And the company had a big verdict rendered against it. And they said, we understand incentives. We understand roads and taxes and all that kind of stuff that states use to try to entice you. But what about the judicial system? I mean, we got hit with this big verdict. We don't think it's remotely fair. And is there a way to evaluate the judiciary of a state to see whether or not, they always find for the plaintiffs, that sort of thing? And I said, well, I don't think so. I mean, every case is different, a different law applicable to different facts. So I just don't know how you do that. At the same time, or shortly thereafter, I had an American company, a very large company that we represented, that asked me point blank, is there a way you can come up with a scoring system on judges similar to what we do with legislators? For example, the state chamber in a given year might pick out its, 20 most important pieces of legislation that impact the business environment of a state. And they take all the legislators in Oklahoma House of Representatives or Senate, and they see how they voted on those 20 bills, and they score them. 80%, 60%, 10%, whatever, because they're all voting on the same issues, the same bills. And so it's easier to come up with a scoring mechanism. It occurred to us that, wow, maybe we could do that at the appellate level. Because when you get to the appellate level, the judges are voting on those same cases. And so we began to think about it, and that particular client was interested enough to pay us handsomely to think about it. And so we did some test runs in Oklahoma and Texas on specific cases. And we found that if we came up with a criterion which would throw out cases where all the judges up and down the line agreed, so it was a unanimous opinion. If we threw out cases that didn't particularly impact the environment, like probate, we didn't even look at criminal law, we didn't look at family law, but we looked at cases which have a direct impact on the climate of the state, the economic climate of the state. And we came up with categories, like medical malpractice, so on and so forth. And we began to run some tests on that criteria, and we found that when you did all that, and it was particularly so in Oklahoma, which it had a long and stable membership on the court, then you found that on the same cases, the judges varied greatly in scores. Now, all the judges say, hey, we don't make law, we just apply the law, we just call balls and strikes, we're not making up the law, and yet you had these vast differences on the same cases. And so we looked at literally hundreds and hundreds of cases, and we found the great disparity in scores, no matter how many cases we looked at. So it was interesting because we could actually come up with a scoring mechanism. And it became clear what we all know intuitively, and that is judges bring to their job a certain philosophy. And so the object of the exercise was to kind of ferret out what that particular judge, what their philosophy was, what they carried into a case, if you will. And by that maybe help predict the environment of the state, certainly as it impacted the business environment of a state, or the economic job creation, you might say, environment of a state. And so we actually developed a system to do that. And what really interested me was the very first case that I looked at was a railroad case, a workers' comp case. And I actually have a slide right there. It is. You go, okay, what the heck is that about? Well, I looked at a case in 1996, and a driver was driving his truck slowly, but driving his truck. Frankly, his passenger, who apparently was sitting on his lap, clad only in a t-shirt, was killed. He, who was discovered to have his pants pulled down and was severely injured but not killed. Well, the defendant said, hey, wait a minute. This was clearly not within the scope of employment. I mean, it was horseplay. And you can't cover somebody in the workers' comp if they're engaged in horseplay. And so it went to the Oklahoma Supreme Court. And the Oklahoma Supreme Court ruled that, okay, even though he confessed to the first responder that they were engaged at the time his truck rolled onto the track, that because the truck was moving, he was, still within the scope of his employment, and they awarded damages for workers' compensation. It was a 5-4 decision. The dissenting judge, Judge Watts, said he said in writing, they were clearly engaged in sexual intercourse, and it should not fall within the scope of his employment. Anyway, I looked at that case and I said, you got to be kidding me. So what did that case do? Well, that case told employers and prospective Oklahoma employers that their insurance rates in Oklahoma for workers' comp were going to be pretty high. Because if that fell within the scope of employment and not into the horseplay exception, then anything would. So that single case really piqued my interest into looking into these issues. Now, what is our climate now in Oklahoma? You might go to the next slide. What we have going on out there in the marketplace is we have plaintiffs' lawyers not only advertising on billboards, we all know about that, not only advertising on TV, but they have developed a very sophisticated way to gin up class action lawsuits on social media platforms, Facebook, Instagram, what have you. And so this is just a way for them to gin up more lawsuits. Next slide, please. So, here you are, look, money, here's this lawyer. This is on ACH fees, trying to gin up lawsuits against banks. And so we find this phenomenon just increasing. I know at spring break, they were trying to round up kids who went on spring break and say, keep your receipts and look for these numbers because they might have violated an act and put one too many digits on the receipts you've got. And so they develop a class and they sue. So that's just an additional new issue that we're dealing with besides the television advertising and the billboards and that sort of thing. Then we also have in Oklahoma, next slide, please, the very famous Johnson & Johnson opioid trial. Now, I don't want anybody to think what I'm talking about here is in any way a defense of companies that made opioids. But it does raise some very interesting issues now, because what happened is that the Attorney General's office hired professional trial lawyers. They, of course, everyone knows, made millions and millions of dollars off this, had a contingency case. And they, Johnson & Johnson had sold about 1% of the opioids in the case and had a $572 million verdict rendered against them. There was a math error, and that was lowered to 400 and something million dollars. But that is being criticized, not because they had a verdict rendered against them, but because the theory that was used was they created a public nuisance. Now, public nuisance traditionally has been used for property cases. Someone in a neighborhood lets their dogs out and they bark all night, keep everybody awake. Or they do something on the property that causes flooding on all their neighbors' properties, or they have a go-kart track, put up stadium lights at night, whatever. And the remedy has been to go abate that public nuisance. What this case did was expand the idea of what a public nuisance is to where an FDA-approved drug through marketing now becomes a public nuisance. There's only been one other appellate court in the nation, that was in California, that allowed a similar case to go forward where it wasn't a property situation. And so that is now on appeal, the Oklahoma Supreme Court. We'll see what they do. But our concern for economic reasons with using that theory as opposed to negligence or even reckless disregard for the health and safety of others, those kind of traditional tort theories. The problem with using public nuisance is, can it be used against energy companies? Can it be used against meat companies? Can it be used against anybody that decides, well, that causes a nuisance? So that's the issue. And because it was settled or the verdict was rendered on that basis, the American Tort Reform Association has continued to use Oklahoma, or list Oklahoma as a judicial hellhole. So not a friendly place to do business. This, of course, is something that general counsels of companies look at these days. There's little doubt it'll have a dampening effect on the economic climate in Oklahoma as companies are looking to expand or locate here. So I don't think anyone believes that these companies who sold opioids and marketed opioids, even though they were approved by the FDA, I don't think anyone believes they shouldn't be punished in some way, shape, or form. It was the public nuisance theory as opposed to traditional tort theory, reckless disregard. that is causing this very negative publicity in the business community. Well, we'll see what happens when it goes to the Supreme Court. The Supreme Court also has unhappily begun to delve into areas, and you might show the next couple of slides. I'm trying to move quite along. So this is from the American Tort Reform Association. This is what they've said about Oklahoma, and they filed an amicus brief in that case because of the theory used, the expansive nature of trying to apply nuisance, public nuisance to marketing in this instance. Then you might go to the next slide. So, you know, they're listing us as a hellhole. Well, the problem is that creates real problems in trying to attract business to the state of Oklahoma. So this is our scoring mechanism. This is what it looks like. This is 2019. And this is the last full study we've done. I'm going to show you, so you see Colbert, who's now retired, Combs, Edmondson, Gurish, Cogger, and then Jim Winchester are, solid, and Justice Winchester has just been solid all through the years. He was joined in the past by Justice Taylor, and it's just been a stalwart in terms of staying within the traditional boundaries of a court, not second guessing the legislature in every instance, not trying to make law from the bench, but staying within traditional boundaries. Next slide, please. Now, these are preliminary results for 2021. And so we have more work to do to finish this, but you can see that we've had new justices appointed. And so there's our solid James Winchester, Justice Winchester. Rowe, again, preliminary, but he's scoring very highly. Kane, new justice, scoring very highly. Darby is up there at 66%, new, and then you had the other ones there. Colbert retired in February, so that will go to the Judicial Nominating Commission for his replacement, and then that'll go to the governor for the governor's selection. Now, interestingly enough, we have a retention ballot in Oklahoma. We don't elect at large, or we don't have partisan elections, but we do have retention ballots. And so you'll look up there, and who's up next time will be Combs, 40%, and then Rowe and Winchester will be up next go around on the next retention ballot. Next slide, please. This is, we do our work for the Institute of Legal Reform at the U.S. Chamber of Commerce. They have been our client for 25 years, ever since we developed this methodology. So they go in and look at this. Sometimes they get involved in judicial races or selections if they've got a particularly bad judge. The political side of this was once run by Tom Cole before he ran for Congress. And you can see where Oklahoma is 0 to 49 favorable cases. So we fall into the bad category. And so that is our nationwide comparison. Next slide, please. I think most people know this. This is how our Judicial Nominating Commission works. This has been in effect since the 1960s, when we had a big Supreme Court scandal. And we went to a modified Missouri plan, they call it. And so we have 6 attorney members, and the rest are lay. You see the lay members over here, and then 3 at-large members. And the Judicial Nominating Commission selects its own chair. And so this is as a result of a chamber-backed reform to try and lessen the influence that the trial lawyers had over the court. And so This was a great reform, and I think it's beginning to bear fruits if these at-large members and lay members are people who will not be unduly influenced by the trial lawyers who may be on the commission. So that becomes critical. This ought to be a big deal. So when those appointments are made, they ought to be stalwart people who have business experience. And this is really critical to cleaning up our situation. Next slide. This is just the retention ballot, what it looks like. We've never had a judge not retained in Oklahoma. They have in other states, but not in Oklahoma. So you see who this is a copy of the ballot in 2018, just to remind you. Now, what can you do about it? Next slide, final slide. As you know, we do this basically nationwide at the request of the Institute of Legal Reform of the U.S. Chamber of Commerce. But when we started in the 90s, we began to do it on a state-by-state basis. The U.S. Chamber now buys the work product. We're located here in Oklahoma. We have a staff of attorneys who are very experienced in these evaluations. And I just wanted to throw this up here. You might think, what on earth is that? I just want to use one example of what Texas did. Texas had a terrible court. In fact, I remember back when 60 Minutes was pretty objective back in the 90s, and they ran a special saying justice for sale. And it was all about the Texas court. So Texas formed a civil justice league, and they began to organize large and small businesses to try to get fair-minded judges on, who, some judges never met a plaintiff they didn't like. And so they were trying to clean it up. So part of the way they did it is when you went and picked up your dry cleaning, the members of the Dry Cleaners Association put a ballot on the dry cleaning that you picked up, a ballot suggestion, because people don't know who these judges are. They don't have the information. And so it said, hey, the Dry Cleaners Association is for these people. And they changed their court really in 2 election cycles, from a really awful court to a fair and balanced court. And you had like Justice Cornyn, who's now U.S. Senator, was one of the people we evaluated. Later, Greg Abbott, now the governor of Texas, was one of the justices we evaluated. And that's just one small example. In Michigan, they used a lot of advertising and handing out information. It can be done. It's difficult on a retention ballot, but it's something that can be done. And I'll just close with this, and I guess I've run past my 20 minutes, so I'll close with this, Chad. Our court has been cutting away at our reforms in the area of workers' compensation. We spilled a lot of blood to get that cleaned up, to move a little bit more toward an administrative system, to put some guidelines, some guardrails in place on workers' compensation to keep our rates down. I know specifically of companies who left Oklahoma because of the workers' compensation laws and rates they had to pay. And so we finally got that done. But unfortunately, the court, Winchester excluded, has been cutting away at that with some decisions which are really beyond the pale. And they've been using a theory called special laws to do it primarily. What's a special law? Well, a special law you might think of like the penalty for targeting in football. It's a targeting for a specific class of persons. And they have expanded that theory and have said things were special laws that were never intended to be special laws. And in fact, they're not special laws. And in fact, if you use their theory of what is a special law, if you were consistent, you'd throw out the entire progressive income tax system. you'd have to change criminal law because all laws, in some respect, apply to people different than others. The type of crime you commit, the consequences of your crime, even though you might have done the exact same thing. We're all taxpayers. Why should some taxpayers be penalized more than others or pay more tax? So I'll just say this, and I can answer questions about these cases. And if not, Jan's here to make me look good. So she can answer questions as well. But to say that anytime the legislature differentiates between two classes of people, that one is a special law, is, I would say, patently absurd. But it's what our court has done. And it effectively has led, in our opinion, to legislating from the bench. Texas, we were asked to do a comparison of Oklahoma and Texas. Texas had workers' comp reform, went to kind of an administrative system, had an opt-out provision in there for companies who qualified and could carry their own workers' comp costs and systems. And we compared the two states. Oklahoma scored very, very low, with the exception of our minority dissenting judges. Texas, on the other hand, scored very high. They didn't go second guess the legislature on everything. They deferred to the legislature, which is their proper role. And so the contrast could not have been greater. On our scoring sheet, the Texas judges were all basically over here on the right. They scored higher. Oklahoma, with the exception of a couple of our judges, scored low. Could not have been more pronounced. And so that is the environment we're working in. And with that, Chad, I've gone over. I'm sorry. I'll apologize later. And now, so any questions?
Well, I'll forgive you if our audience forgives us for not giving this a TVMA warning in your court case from the beginning. We got everybody's attention, I think, right away. So very good presentation, Sam. We'll open it up to questions. I know that Ben has been fielding some questions. If you have a question, just either raise your hand or jump in the chat, and we'll go from there. Jim Newport has a question. Besides the public nuisance concern and the need for business conservatives on the JNC, do you have any comment on the reptile theory used in nuclear verdicts?
I don't. Jan, do you? Oh, Jan's muted, but anyway, you got to unmute, Jan. I'm sorry, I don't. That's now Ben probably does.
Well, I was going to say, now I've got some homework to do.
Yeah. Okay.
Ben, you had a question.
Not
Jan, did you want to weigh in on that?
No, I'm not familiar with the reptile defense.
Well, Jim Newport, you get the gold star for stumping everybody. So unless somebody hacked into his account, but.
Can I make a quick comment, Chad?
Sure.
Yeah, so in short, and I'm the least trained on this, but it contributes to Oklahoma being a judicial hellhole. But plaintiff lawyers, particularly in accident cases and often with trucking, literally purchase and get educated by trial bar attorneys who've written curriculum as to how to use this thing called the reptile theory. And it steers, but it instills fear into the jury throughout the trial, meaning big bad company puts profits over people. I don't think it's specific just with trucking, but it is literally a bought and purchased curriculum out there, and has been proven very effective, and it has created enormous verdicts, nuclear verdicts, and contributes to the hellhole. So sorry, I didn't realize that maybe that was a subsurface issue, but if you look into it, I think it'll jump out at you, and it is a huge problem. I know the ATRA is aware of it as well. Sorry, I'm out.
No, that's great. It actually, as you were describing it, I remembered I've been told about this before. It involves focus groups with juries, mock juries, and a whole methodology. The reason it's called the reptile theory is because it it tries to get to the reptilian part of people's brain, so their most basic instincts. So yeah, I did know about that. Got a couple other questions coming in. One is, Sam, have you looked at judges before they get appointed to the Supreme Court, and then seen if your scoring was predictive of how they acted once they got on the bench?
Yes, we have. And so depending on the interest of the governor, we can get involved very early, and we have been in the last 3 appointments. It's a great question. So what do you do if someone has not been on an appellate court, since we evaluate appellate judges? Well, if they were a trial judge, we can go back, see which of their cases went up on appeal, and backtrack and get kind of a feel. Maybe not as perfect as if they had a long history on a court, on an appellate court. But, we've been doing this for a quarter of a century, and we've gotten pretty good at getting a feel for what someone's philosophy is. So the answer is yes. We have also developed a series of questions to kind of ferret out a potential jurist's philosophy. And so when we have a governor who is interested in our opinion, yes, I think we can be of real help. And so the answer is definitely.
I'd like to add one
Go
thing to
ahead.
that. We found throughout the states that most people believe that a Republican will score well as to their economic effect, and a Democrat will score poorly, but that is not always the case. They're not always in sync. So this study gets more information than just Republican or Democrat.
Yeah, it's just the facts. That's what we deal in, and we lay partisan issues aside. So good point.
So some decisions are a bigger deal than others. The damages cap case comes to mind. Do you try to weight the decisions based on their impact in your scoring?
Sometimes we do. For example, in certain cases, I'll just use the Maxwell case, which is one case where the court took a step to help gut our workers' comp reforms. They maybe had 2 issues in that. One was a permanent partial disability, where they said that the court cannot take into account the fact that someone actually returned to work. And secondly, it was a special law because it treated classes of workers different. That is, injured workers who were well enough to come back to work versus injured workers who said they weren't. Now, there's 2 issues there in that case. So when it's a critical case, sometimes we will look at both issues. Otherwise, we just look at the seminal issue in that case and score them on that.
And then,
Ben, you got probably time for one more.
yeah,
Any
so
other
we got
questions from the group, or Ben's got some that have.
Yeah, so we've got a question about whether, I'll pack 2 into this. Is there an oil and gas nuisance suits getting any attention at this time? As asked in our chat. And then I'm curious, Sam, if you could just briefly touch on if you see any correlation between the selection method for judges in a state and what their scores look like on their courts.
Yeah, very interesting. Interesting debate there, because if you have an organized business community and you have elections in a state like Texas did, Alabama, other states I can point to, then if the business community is really organized, they can impact the judiciary very quickly. And when you get down ballot to where the judges are, a little information goes a long way, because a lot of people don't even vote for judges. you know, and a lot of them who do vote on a name they like, you know, going to the horse races and, well, I like, you know, Paint Boy. I mean, I'm gonna put my money on Paint Boy or something. We actually found out that if you had an Irish last name, you were more likely to be elected than if you didn't. I mean, things like that. So my point is that a little information, and all this is objective information, a little information properly used can go a long way. Now, a judicial nominating state like Oklahoma would be, an election isn't going to have as immediate impact because you've got these retention ballots. People don't know what to do. They don't have information. So you're really in a judicial nominating state like Oklahoma, which now scores as perhaps the worst from a business climate of all judicial nominating states. Let that sink in. Then it takes a while. I'll just make we've got holdovers that have been on the court a long time from previous administrations who were not concerned about this issue. And so it becomes critical to appoint the right people to the Judicial Nominating Commission and then have a governor that is interested in the topic and understands and cares about the impact that the judiciary can have on the economy. If you put that together, then here in Oklahoma, we're almost a divided court now, probably 4-4-1. Well, if we replace Colbert with the right person, we can start to edge over and give people like Justice Winchester, who's been fighting the good fight for all these years, some reinforcements. So that's kind of the difference between the two.
Hey, real quick, Sam, and if you have, we'll end with these two. And Ben asked it before, but have you seen any interest, or is there anything that oil and gas is potential exposure on public nuisance?
Yeah, we are kind of waiting for that shoe to fall, and that could come from not only fracking or oil and gas operations, but if you follow the public nuisance theory on opioids, it could be just marketing gasoline and causing environmental damage. And the one appellate court that has gone that way was out in California. And we just expect in California that some of the environmentalists out there will probably start the ball rolling. And we expect them to maybe sue some energy companies and health risks, that sort of thing. I expect you're going to see this happen against hamburger restaurants because they're unhealthy, maybe gas stations who sell alcohol or tobacco. I just think all those are ripe for lawsuits that we're going to have to begin litigating if that public nuisance theory is expanded.
We'll end with this one. It's probably more of a comment. It's a good question from Chet Vinson. And he said, do we see that what we feel are clearly unwarranted decisions in the affirmative regarding employees applying for unemployment benefits? In most situations, they're awarded these benefits regardless of the reason for leaving. And his question is this also an area where our judges have weighed in on the decision? Is there anything in that space that impacts or you see as a potential impact?
Unemployment benefits?
Yeah.
Yeah. Jan, I'm trying to think in Oklahoma specifically. Now, we do this basically nationwide, wherever the U.S. Chamber wants us to look. And I'm trying to think in Oklahoma, do we have any unemployment cases that you can think of?
I haven't seen any in the appellate courts yet, but I have been reading California lately. So my head's in California, but I haven't seen any at the appellate court. There may be some at the trial court.
I assume too that I assume that what Chet's seeing is probably emblematic of an expansion of kind of the mindset of liability against ruling against employers and defaulting to employees, and that's probably emblematic of some of what you all see generally as well. So probably not a good sign that Chet's seeing quite a bit of that in that UI space for sure.
Yeah. And if we get the right court, and right now we've got a legislature that, you know, you would think would be open to addressing this issue. If we get the right court who will uphold the legislative intent and not act as a legislature, then we can begin to correct these problems, probably with one more appointment to the Oklahoma Supreme Court. So we're hopeful.
Great. Well, thank you all very much for joining us, Sam. I appreciate you being on, and Jan for weighing in as well. Thank you all for the good questions. And our winner of our door prize is, according to Lindsay, who's in charge, Jeff Koval from CEC Corporation is our winner. So Jeff will be getting that out to you. And we appreciate you all joining us. Thanks for being engaged with the chamber and staying abreast in these issues. These are really impactful issues that impact business. We really enjoy working with Sam and look forward to trying to make sure that we're doing our part to address the issues of expanding liability for businesses. We want Oklahoma to be a friendly place for business, and definitely get off that judicial hellhole list. That is not a distinction that we want to keep in the state of Oklahoma. So appreciate y'all joining us. Have a great afternoon. Take care.
Thank you.